For nearly 30 years, this series has been about one idea. Your medical records belong in your doctor's office, not in other hands. In 2022, that idea met its most personal test. The Supreme Court overturned Roe v. Wade. State laws on reproductive care split apart. And suddenly, medical records could become evidence. What happened next was a regulation, a courtroom, and a lesson in how far a privacy rule can reach. This is the story of HIPAA's hardest chapter. Health Tech Frontier. Here's the tension the framework had never faced. The privacy rule has always permitted certain disclosures, including some to law enforcement, under conditions. But after 2022, care that was legal in the state where you received it could be investigated from a state where it wasn't. Same records. Same rules. Entirely new question. Should health information cross that line? HHS answered in April 2024 with a modification to the privacy rule. Its core was a purpose-based prohibition. Regulated entities could not use or disclose health information to investigate or punish seeking, obtaining, or providing reproductive health care, where that care was lawful under the circumstances in which it was provided. Effective that June. Compliance due by December. The mechanics mattered. That phrase, lawful under the circumstances, meant the law of the place where care happened governed, not the law of whoever came asking. And for certain requests, the rule demanded a signed attestation. The requester had to formally affirm the information would not be used for a prohibited purpose. Paperwork as a checkpoint, the request itself now left a trail. The rule was challenged in federal court in Texas, a case called Purl versus HHS, and on June 18, 2025, the district court ruled. In the court's holding, HHS had exceeded its authority in issuing the rule. The remedy was sweeping, vacatur, nationwide, not paused, not narrowed, struck down everywhere a year after it took effect. An appeal was docketed, then the government declined to pursue it, and in September 2025, the appeals court dismissed the case. That was the end. The reproductive health privacy rule is gone. The baseline privacy rule, the 2013 framework from our last episode, governs those records again, along with whatever each state's own laws provide. On this question, America is a patchwork once more. But 2024 produced two privacy rules. And the quieter one stands. Substance use disorder treatment records had lived under their own separate confidentiality regulations since the 1970s, stricter in places and famously hard to reconcile with HIPAA. The 2024 alignment rule fixed that. One consent can now cover treatment, payment, and operations, and HIPAA's breach notification protections apply. Effective April 2024. Compliance, February 16, 2026. Months ago, as this episode airs. So the ledger of 2024. One rule struck down by a court, one rule quietly in force. And a fact worth sitting with. The fight was never about whether your records deserve protection. Every party claimed that ground. The dispute was about who gets to draw the line, the department that writes the rules, the courts that review them, or the Congress that, as Episode 1 showed, never passed a health privacy law of its own. From a paperwork law in 1996 to a courtroom fight in 2025, the history of HIPAA is a history of America deciding, decade by decade, what health privacy means. And the story isn't over. In March 2026, Washington finally kept a promise it made back in 1998 and finished one of HIPAA's original assignments. That's the series finale, the Claims Attachments Rule. Subscribe. One episode left. This has been Health Tech Frontier. Subscribe for the next chapter.